Perhaps while we wait, you all would be interested to know the language included in the Senator Byron M. Baer Open Public Meetings Act. Section 10(4)(7) says legislative findings and declaration. The legislature finds and declares that the right of the public to be present at all meetings of public bodies and to witness in full detail all phases of the deliberation, policy formulation, and decision-making of public bodies is vital to the enhancement of the proper functioning of the democratic process. The secrecy of public affairs undermines the faith of the public in government and the public's effectiveness in fulfilling its role in a democratic society, and hereby declares it to be the public policy of the state to ensure the right of its citizens to have adequate advance notice of and the right to attend all meetings of public bodies at which any business affecting public is discussed or acted upon in any way, except only in those circumstances where otherwise the public interest would be clearly endangered or the personal privacy or guaranteed rights of individuals would clearly be in danger of unwarranted invasion. The legislature further declares that it is the public policy of this state to ensure that the aforesaid rights are implemented pursuant to the provisions of this act so that no confusion, misconstruction, or misinterpretations may thwart the purposes thereof. The legislature therefore declares that it is the understanding and intention of the legislature that in order to be covered by the provisions of this act, a public body must be organized by law and be collectively empowered as a multi-member voting body to spend public funds or affect persons' rights, that therefore informal or purely advisory bodies with no effective authority are not covered, nor are groupings composed of a public official with subordinates or advisors, who are not empowered to act by vote, such as mayor or the governor, meeting with department heads or cabinet members. That specific exemptions are provided for the judiciary, parole bodies, the State Commission of Investigations, the Apportionment Commission, and political party organizations. That to be covered by the provisions of this act, a meeting must be open to all the public body's members, and the members present must intend to discuss or act on the public body's business. And therefore, typical partisan caucus meetings and chance encounters of members of the public bodies are neither covered by the provisions of this act, nor are they intended to so be covered. (10)4-8) Definitions. As used in this act. Public body means a commission, authority, board, council, committee, or any other group of two or more persons organized under the laws of this state and collectively empowered as a voting body to perform a public governmental function affecting the rights, duties, obligations, privileges, benefits, or other legal relations of any person or collectively authorized to spend public funds, including the legislature, but does not mean or include the judicial branch of the government, and any grand or petty jury, any parole board, or any agency or body acting in a parole capacity, the State Commission of Investigation, the Apportionment Commission, established under Article 4, Section 3 of the Constitution, or any political party committee organized under Title 19 of the revised statutes. Section 3 is particularly relevant. Public business means and includes all matters which relate in any way, directly or indirectly, to the performance of the public body's function or the conduct of its business. D, adequate notice means written advance notice of at least 48 hours, giving the time, date, location, and to the extent known, the agenda of any regular, special, or rescheduled meeting, which notice shall accurately state whether formal action may or may not be taken, which shall be 1, prominently posted in at least one public place reserved for such similar announcements. 2, mailed, telephoned, telegrammed, or hand-delivered to at least 2 newspapers, which newspapers shall be designated by the public body to receive such notices. Thank you for joining us, Chairwoman.
Good morning. Thank you for joining us. 10:13. Meeting started at 10:13. There you go. Do you have something, Rosemary, or do you leave her out this time too? Good morning. I'd like to call to order.
I object to this meeting under violation of the Open Public Meetings Act. I was never notified by a member of this district that this meeting was to occur.
Didn't notify her.
I have not received notification from this chair in any way at all.
I will do a roll call. Call to order. 10:14. Roll call.
Commissioner Brown?
Here.
Commissioner, oh my God. Gaskell?
Here.
My brain just went. Commissioner Shepherd?
Here.
Commissioner Logue?
I am present as a representative for the taxpayers who put me in this seat.
So you're here? Can I have a pledge of allegiance and a moment of silence, please? I pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please be seated. Going right into new business.
Motion to approve 2025.
Before we move in, I would also like to object to this meeting that was not
Already have a
given
motion to
48
approve the
hours
Resolution
notice.
on the table.
Second.
Roll call. Commissioner Brown?
I'm sorry, could you repeat what we're doing?
Oh, I apologize for that. It's kind of hard when I'm in. Before we go into the, as I already have a first and a second, I'm just gonna backtrack due to the interruptions. The New Jersey Open Public Meetings Law, NJSA 10:4-6, was enacted to ensure the right of the public to have advance notice of and to attend the meetings of public bodies at which any business affecting its interests is discussed or acted upon. In accordance with the provisions of this act, the Board of Fire Commissioners of Fire District Number 1, Township of Mount Holly, has caused notice of this meeting to be published, having the date, time, place, and agenda to the extent known thereof, posted as follows. Published on the district website on September 17th, 2025. Filed written notice with the Township Clerk on September 17th, 2025. Posted written notice where applicable.
Can you please tell us where the other written notice was applicable and where it was posted?
Give them this person a second. Can you do a roll call, please?
Yes. The resolution 2025-046, which I already have a first and second on, is the resolution authorizing the award of a
I'm sorry, I have,
contract for the
is
interim
Commissioner Brown now the chair?
emergency appointment of council to continue working operation of the district.
Well, we have some questions regarding what you sent us. We're not allowed to ask questions now as commissioners.
I can appreciate that you sent us this information at 6:40 last evening so that this would go quickly, as you said in your email. You sent an agenda with no invitation to me and said we should have all of our questions directed to the clerk. That number was not answered for my questions. So will you please take the moment and address them now?
Per the new law that was signed into act by the governor, I think it was this year, if I'm correct, council.
Yes.
I'm sorry,
June 30th.
Can we
Are you-
do this council first, and then we can start speaking?
Well, no, I actually have questions
Our
about
bylaws-
the accountant.
Is this conversation between up there or everybody's supposed to hear? I can't hear
Can
Mr.
Mr.
Brown.
Brown turn his microphone on, please?
If the commissioners have questions about the resolution, they should be able to ask those questions prior to.
Prior to the vote, okay. I still have a.
So I have questions about the meeting. Is it, like, our bylaws say that anything on this agenda should be addressed by the chair and reasonably explained. So I'm sorry if you feel like I'm injecting something here that doesn't belong, but as I only just got the bylaws from a member of the public yesterday, even though I've been requesting them since I took this seat in December, I have a little catch up to do. So now that I'm aware of the fact that you should be adequately informed to be able to explain this to us, I'm asking, in your role as chair, can you please explain to me where the posted written notices were applicable? Because historically, up until this
Can we
meeting,
maintain this to the question that was the resolution, please?
no, we can't, because we haven't gotten past the Open Public Meetings Act. We skipped over it out of order, and then we went back to it. So if we're back to it, you're not the chair, Josh.
You're not either. No, you will speak all meeting.
Well, I have questions about the resolution either way.
Thank you.
So, though I do disagree with this meeting, and I do not believe it is legal for us to be currently having a special meeting due to lack of notification, I'm here to represent our township and the people that elected me. Now, I'd like to know whether or not when Brown and Connery started working for us, and when we received the proposal for their conflict counsel?
They were retained for conflict counsel due to the shared services agreements.
Now, as
So
part
they are
of,
still conflict counsel until they are voted in as our interim counsel, since we lost our other counsel.
when was this proposal received?
Which proposal?
The one that you provided us with at 6:20 something yesterday. There's actually no date on the Brown and Connolly LLP proposal to the Mount Holly Fire District Number 1 to serve as conflict counsel. There's no date.
Thank
It
you.
was early August. Why was this not provided to the rest of the board prior to last night? Why were we given it just now in the email and not in early August when it was presented by Brown and Connolly?
In early August, that was under the director's purview. He had the right to retain conflict counsel,
Without any board approval?
yes, because it was conflict counsel.
Now that it's not conflict counsel,
Now we vote them in, because they are still our conflict counsel until we vote them in as our interim counsel.
now as interim counsel, what are we going to do and what's the plan if we have issues with Lumberton? Since we do have continuous ongoings with them and West Hampton, as they are also representative of those two districts.
That I don't have the answer for, because I'm not a lawyer.
So wait, the director did not inform you of what would be the potential conflict there? Or what would be the answer to any potential conflict?
As the director was removed as of Friday,
I know, but I got emails from him as recent as Wednesday. That you forwarded him emails from me and then he emailed me. So exactly why couldn't you have asked?
because it wasn't on my mind, I was too busy trying to do everything else.
Okay.
And if that's not a good enough answer, I apologize, but
Okay.
I've been here every day trying to keep this district running.
Well, there's 5 of us, you could have asked for help. Now, moving on,
Actually, on more than one occasion.
unless, if we have a conflict with one of your other, and am I allowed to ask you as something that, right? If we have a conflict with West Hampton, which we have a shared service agreement, or Lumberton Township, which we occasionally run into on calls, and are adjacent to us, exactly how do you will handle those situations as conflict lawyer for conflict?
Understood. Any situation that may arise with any of those entities or any other entities that we represent, we would always do a conflict check internally. We're always assessed on a case-by-case basis. Maybe not every matter that involves those entities would be a conflict, but some may be, or some may be too close where the perception would look like a conflict. In those situations, we would certainly recuse ourselves where conflict is determined or again, perception.
Speak into the mic.
We can't hear.
Please.
Could you please speak in the mic?
Maybe you.
You gotta bring it closer now.
That is how we would handle it.
We didn't hear
Can
anything.
you please bring the microphone closer? We can't hear you.
It can't be a public meeting if you can't hear it.
Oh. Thank you.
Could you remind summarizing that and just saying it one more time so the crowd can hear you?
Sure. In any matter involving this district, whether it involves another public entity that Brown and Connery represents or not, we would always assess the matter and do an internal conflict check. Those are evaluated on a case-by-case basis, depending on the facts and the issues, and depending on whether or not we would either be adverse to an existing client, or if the perception of the public would make it seem as if we could not be fair and arbitrary when guiding this district on whatever issue it may be. So in the event that a conflict does exist, or there is a strong perception of a conflict, we would certainly recuse ourselves in those situations.
I have another question. Have you been conducting business for the district without resolution approval outside of the conflict? So I understand there was some conflict where between us and the township. Have you been conducting other business for the district? According to our, other lawsuits, sending letters. I believe Brown and Connery sent a letter September 11th in representation of the district. Yet we don't have a resolution outside conflict yet.
We could discuss that in closed session.
Okay. But that would be outside of a resolution, would that be illegal?
I'm not answering that.
Oh, okay.
I mean.
Can't hear.
Can't hear.
That question doesn't really have any context to it. And I'm not sure what the premise is. I don't know what you mean by other business. But we're certainly not aware that we've been engaged in any illegal conduct whatsoever.
Can't hear.
That's why you have a mic.
Can I continue now?
Wait, does anyone else have any questions? No, board, I mean.
All right, calling for a roll call for resolution 2025-48, resolution authorizing the award of a non-fair and open contract for interim solicitor. Roll call, Mr. Brown?
Yes.
Oh, hold on. So I can write it down. Sorry, I'm not used to doing everything. Ms. Lowe?
Yes.
Ms. Shepherd?
No.
Ms. Gaskell? Yes. And Chairwoman Saucier, which is me, yes. Motion passes. Next order of business, resolution 2025-47, resolution to go into closed session pursuant to NJSA 10-4-12 and 13 to discuss personnel matters, contracts, and attorney-client privilege. Formal action may be taken.
So moved.
Can't hear with your hand in front of your mouth.
I don't know. Okay, I have a first and a second, and a roll call. Mr. Brown?
Yes.
Sorry, I'm writing, so. Ms. Lowe?
No.
Ms. Shepherd?
Yes, but with the understanding that I do believe that this is an illegal meeting.
Yes to suffice. Ms. Gaskell?
Yes.
And Commissioner Saucier, which is me? Yes. Motion passes.
Chair, before we go into close, I do need to make a public announcement about this. The board has passed resolution 2025-47 to go into closed session. The topic of the closed session will be resolution 2025-48, resolution appointing the director of fire services and authorizing chairwoman to negotiate employment agreement with same. Minutes of the closed session will be kept and will be made available to the public if and when the need for confidentiality no longer exists. However, at all times prior to disclosing those minutes, they will be subject to redaction based on the attorney-client privilege.
Can I ask a question?
Thank you.
Sir, to your knowledge, has 2025-46 been published to the public?
Resolutions are not published until they are approved, until they are completed.
I'm sorry, they knew about this meeting, why we gotta go to closed session?
They didn't know that meeting. It's personnel issues.
They did.
Not all of them. One of the issues wasn't everyone by the meeting.
That's what I'm saying. Why did you?
They didn't want him to attend. No, they weren't.
There's record, if you guys can be an official.
How did you know?
Well, I
You
mean,
get her, she's a liar, so.
I mean, like, I'm a member of council, if the clerk were to like send an email notification for a special meeting and